Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 131. I'm very pleased to be able to confirm that the interview with Judge Brian Doyle, the President of the Employment Tribunals in England and Wales, on behalf of the Employment Lawyers Association, well, that was recorded last week, which is why we're a week out in our fortnightly podcasts for Mayor Brown. I'm not quite certain when that podcast will come out. It may indeed come out in two parts. I think we're still sort of work that out. But I'll keep you posted. It's a really interesting podcast, both about Judge Brian Doyle and his path through and what he does as president, but also, obviously, his thoughts on the future for the employment tribunals. For our own podcast series, of course, we have three cases of general importance this week. First, we have a case on what amounts to a provision, criterion or practice under the disability discrimination legislation. And secondly, we've got a case involved on the extent to which there is priority protection for pregnant workers under EU law in a redundancy situation. Thirdly, and really breaking a self-imposed rule, a case that doesn't change anything as such, but might well point to significant change coming in relation to law on unfair dismissal. Listen up, all will become clear. As always, please remember you can access the podcast. It's via iTunes. It's on the Mayor Brown website or YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11. And then we post out the links to all the cases discussed on that feed. So, first up, United First Partners Research and Nicholas Carreras. And this is a case that's gone all the way out to the Court of Appeal and has decided two important points which affect claims for disability discrimination and constructive unfair dismissal. Let's start with some facts. The employee started working for United First in 2011 and initially was working long days, 12, 14-hour days, apparently pretty standard. Inevitably meant he was working late into the evenings. In summer 2012, I think as a result of a cycling accident, there appears to have been an injury that he suffered, and he went back to work. The Employment Tribunal said clearly far too early, but anyway, he went back to work and physically he was in some difficulty. Symptoms included dizziness, fatigue, headaches, and he had problems concentrating. As a result, he reduced his hours at work, leaving at a rather more sensible time. He was working 8 hours a day. After slightly more than a year, the employer started to ask him to work later in the evenings on occasions, and this gradually developed into a routine or an expectation that he would be working late. However, no paperwork was signed. It was never formally imposed on him as a requirement. You can see where this is going, can't you? Anyway, things seem to be going downhill in the employment relationship, and there was a row on Valentine's Day in 2014, and the employee by email said he was refusing to work late in the evening. Things definitely got out of hand. There seems to have been a bit of a ruckus between the employee and one of the owners of the business in front of a number of the other employees. The owner, during the row, demanded an apology from Mr. Carreras, and said if he did not like things, he could just leave. Mr. Carreras consequently 4 days later submitted his resignation, and there were a number of reasons he gave in his letter of resignation, including the conduct of the owner and being forced to work late into the evenings. He also complained about things like late payment of bonuses, for example. Well, inevitably the employee brings tribunal proceedings for unfair dismissal and a claim for disability discrimination on the grounds that his health issues had clearly lasted for more than 12 months, so he is disabled, and he claimed that there was a provision, criterion or practice of requiring him to work late into the evening, and that adversely affected him on health grounds, and as such it would be discriminatory if there was a failure to make any reasonable adjustments, or if there was a failure to make reasonable adjustments that could be justified. At the employment tribunal stage, the employer won because the tribunal accepted there had never been a provision, criterion or practice, PCP, requiring the individual to work late into the evening. It was only an expectation rather than a requirement, and anything less than a requirement, according to the tribunal, did not amount to a PCP. I'm going to follow this point through the appeal courts, and I'll come back and deal with the other point of relevance in the case. In relation to the PCP, the Employment Appeal Tribunal disagreed with the Employment Tribunal. They said that something could be that it was a requirement, but it did not actually have to be imposed on an employee who was kicking and screaming against it. It was enough; it was a strong form of request. The Court of Appeal took the same approach as the Employment Appeal Tribunal. It was not necessary for a PCP to be an absolute requirement. Here, there was a pattern of repeated requests which made it clear he was expected to work late, and that created pressure on the individual to agree. It was more than a request made on individual occasions. An expectation of a working practice was sufficient to be a PCP. Pausing there, I think that's quite a significant point. It allows employees to challenge practices which have grown up or evolved over time, where there's said to be an expectation that things should be done one way or another, without that ever having been formalised into a written document or something that amounts to a clear and binding obligation on an employee. And I think this, frankly, probably accords with a real worldview. In practice, people are often expected to do things, even if no one has actually formally issued a letter which has to be signed or accepted, creating an obligation to undertake whatever the actions are. Equally, of course, it's probably not going to be enough for an employee to say they felt required to do something if that was never vocalised or evidenced in any way. So, what was the second point? Well, the Employment Tribunal also decided the employee had not been constructively dismissed, despite the fact there had been a significant row and the individual had been unreasonably expected to work late. According to the tribunal, there had been a breach of contract which consisted of various matters taken cumulatively, but by itself the row with the employer had not been a single sufficient to amount to a breach of contract. But the Employment Tribunal said the employee had not resigned in response to the breach that the Employment Tribunal had identified. It was apparently common ground. For example, the employee's wife had gone to take up employment in the US, and so the individual would have left in any event to join her. The Employment Tribunal also decided that the employee had resigned just because of the row with the owner, and that the earlier matters, which collectively amounted to a breach of contract in the Tribunal's view, had not been part of the employee's decision to resign. On that basis, the Employment Tribunal felt the claim failed. Well, this point's been considered by the courts before, and the extent to which an employee may have mixed reasons for departure, and whether or not that amounts to a constructive dismissal, has been considered on a number of occasions. The main case, Meikle and Nottinghamshire County Council, took the view that an individual was entitled to claim constructive dismissal if the relevant repudiatory breach, here the row with the owner, was a substantial part of the reason for departure. Obviously, it did not need to be the only reason for departure. Here, looking at the list of factors, none of them were inconsistent with the employee having resigned because of what had happened to him at work. The employee had resigned, the court pointed out, almost immediately after the row, further supporting the idea that the row played a significant part in the employee's decision-making, rather than it being a voluntary departure. The employer was trying to present this as the employee resigning voluntarily, rather than in response to a breach of contract. Here, it was relevant that the employee might have moved to the US at some point in the near future, but that was only relevant when it came to awarding damages. A predictable and assumed move to the US in, say, 3 months' time might place an effective cap on lost wages, but it didn't mean that there was no constructive unfair dismissal in the first place. So I think this is a helpful case to have. Clearly, it allows employees to claim constructive dismissal in circumstances where they may have mixed motives for the resignation, or the individual might have been going to leave at some point in the future in any event. The Court of Appeal's reminder that an anticipated and foreseeable departure might go to limit the damages is also helpful. Since people often have multiple motives for acting in a particular way, it's good to have the test for constructive unfair dismissal restated, just to remind us when we're looking at a set of facts whether or not there's a constructive dismissal. But as the Court of Appeal acknowledged, if it was a substantial part of the employee's decision-making process, then the existence of the other factors, which did not amount to a breach, didn't stop the employee being able to claim constructive dismissal. That's, as I say, that's the case of United First Partners Research and Nicholas Carreras. Second case, and apologies for the pronunciation, Porras, Guisado and Bankia S.A. This is a European Court of Justice case, arising out of a referral from a claim by a Spanish employee. And at one point this case might have been going to extend the employment rights for pregnant employees quite significantly, but fortunately, I emphasise from the perspective of employers at least, the ECJ has stepped back from the brink. The background is that the Pregnant Workers Directive provides, in Article 10, that there is protection for pregnant workers and member states are to take the necessary measures to prohibit the dismissal of workers from the beginning of their pregnancy to the end of their maternity leave, save in exceptional circumstances not connected with their condition. and obviously always assuming that those dismissals are also permitted under any additional protections given by national legislation. Article 10 continues by saying that if a worker is dismissed during the period between the beginning of pregnancy and the end of maternity leave, the employer has to provide duly substantiated grounds for the dismissal. A pregnant worker is defined as someone who has notified the employer of her condition in accordance with national requirements. So you can see immediately there's a bit of a disconnect here. Member states have to provide protection to workers who are pregnant from the beginning of their pregnancy, but pregnant workers are defined as individuals who have told the employer that they are pregnant, presumably at some point after the beginning of their pregnancy. The individual was dismissed by her employer as part of a collective redundancy exercise, and during the collective consultation, the employee representatives agreed certain redundancy criteria with the employer, and these were to be applied when selecting individuals for redundancy or to remain in employment. Two separate categories of employee were given enhanced protection and effectively priority status for protection. Then this was agreed, as I say, between the employee representatives and the employer. Married couples were given this protected status, as were disabled employees. Pausing there, it's not that uncommon to find that married couples are given enhanced protection in selection criteria in Europe, in my experience. Well, whilst the employee was not part of a married couple, she was pregnant, and pregnancy was not one of the groups of employees given protected status. After being made redundant, she challenged the decision to make her redundant, and the matter went all the way up to the European Court. There were a number of issues which the European Court was asked to take a view on. First, the Court was asked to consider whether or not a collective redundancy exercise was an exceptional case, justifying the dismissal of a pregnant worker. Secondly, is it enough for Spanish legislation to say the dismissal is void after the event rather than prohibiting the dismissal of pregnant workers up front? Thirdly, is it a requirement of law, based on the directive, there should be priority given to retaining pregnant employees in the collective redundancy exercise? Finally, is it acceptable for an employer to send out a dismissal letter which refers to the collective redundancy exercise as forming the basis of a dismissal, but doesn't refer to any exceptional grounds above and beyond the mere fact of there being a collective redundancy situation? One of the additional complications was the employer claimed the employee had never told them she was pregnant, and this, they said, was a complete answer to the claim. In practice, this point lost its significance after the Advocate General's decision, where that seemed to be assumed facts because the employee turned up documentation which indicated she had in fact told her employer about her pregnancy. The Advocate General, if you remember, accepted that a collective redundancy situation was not necessarily an exceptional case which justified the dismissal of a pregnant employee. It was up to the national courts to determine this bit for themselves. Was it sufficiently exceptional? However, in deciding whether or not it was an exceptional case, there had to be given close consideration, according to the Advocate General, to reassigning the pregnant worker to another post. However, as I said at the start, the European Court did not go this far. The fact that an employee is pregnant is not sufficient to preclude national legislation which permits the dismissal of the employee in a collective redundancy situation. Equally, the European Court accepted there was no obligation to give pregnant workers priority treatment for reassignment or retraining in a redundancy exercise over and above other employees. The Court also accepted, even if an individual was pregnant, and so was between the start of her pregnancy and the end of her maternity leaves, dismissals unconnected with pregnancy are not unlawful. The employer would need to give substantive grounds for why the dismissal occurred, and this, of course, would also be subject to any additional protection provided by national legislation. But, therefore, dismissals that were part of a collective redundancy exercise would fall within the exceptional cases exception, assuming there was no direct link between pregnancy and the selection of redundancy. Court also downplayed the protection for pregnant employees in relation to the notification which she was to receive. The employer primarily needed to provide an explanation of the reasons for dismissal, collective redundancy, and if it was a redundancy, ought to provide the objective selection criteria that had been used to make the individual redundant. Finally, the Court accepted as well there was no obligation to give a woman priority treatment in a redundancy exercise. There was no necessity to treat her as a priority case when it came to safeguarding her job. Therefore, neutral redundancy criteria, which happen to pick up a woman who is pregnant, are not contrary to EU rights and obligations. In the UK, of course, there is an enhanced period of protection for employees, and that runs during the period of maternity leave. It doesn't start prior to maternity leave and doesn't, as we know, carry on after the woman has returned back from work. If there is a redundancy situation during maternity leave, then in certain circumstances the individual is entitled to priority selection for any suitable vacancy which may exist at the point of redundancy. In the light of this case, that probably goes slightly further than the Pregnant Workers Directive actually requires, although my personal view is that I'd anticipate that this provision has been embedded in English employment law for so long, I can't see there being any question of repealing it. Note, however, that the pregnant worker, if made redundant, or a worker on maternity leave for that effect, is entitled to be provided with the objective selection criteria applying to her redundancy. This seems to be a freestanding obligation, irrespective of unfair dismissal rights, collective consultation, etc. I'm not sure how far this case goes on damages, but it may possibly form a trap for an employer in a future case if the employer fails to offer it in any dismissal letter, unless of course it's been offered previously as part of the consultation process. So that's the Spanish case of Porras, Guisado and Bankia S.A. Third and final case, Riley and Sandwell Metropolitan Borough Council. This is the case which doesn't actually change anything, but flags up something that might change at the future. I'll deal with it relatively briefly, because I think it may be a case that we come back to. The very short set of facts is the claimant was the head teacher of a primary school. She had a close relationship with an individual who was subsequently convicted of making indecent images of children. There was no suggestion at any point that the claimant was in any way involved with that. But anyway, the claimant, the teacher, Ms. Riley, failed to tell the school of her relationship with the convicted individual, and as a result, she was dismissed by her employer. The issue was whether or not the dismissal was unfair. This went to the Supreme Court, and there are two judgments. One was given by Lord Wilson and one by Baroness Hale. Lord Wilson, gave the leading judgment, and the other three Law Lords agreed with his decision. Lord Wilson pointed out that the test for whether or not a dismissal was fair or unfair is laid out by Section 98(4) of the Employment Rights Act 1996. According to that legislation, whether or not a dismissal is fair depends on whether the employer acted reasonably or unreasonably in treating the reason shown by it as a sufficient reason for dismissing the employee, and then that fairness had to be determined, quote, in accordance with equity and the substantial merits of the case, unquote. Now, as we all know, the classic test for applying Section 98(4) was laid down in British Home Stores Limited and Birchall, and that goes back to 1980. And the test is first, whether the employer believed the employee was guilty of misconduct, secondly, did it have reasonable grounds for its belief, and thirdly, did it carry out a reasonable investigation before coming to its view. Lord Wilson, in his speech, pointed out that whilst it is reasonable to look at establishing the reason for the employee's dismissal this way, this three-stage test doesn't seem to fit that well with Section 98(4) itself, which says the test for unfair dismissal is to be determined by the Employment Tribunal, quote, in accordance with equity and the substantial merits of the case, unquote. However, Lord Wilson also pointed out that the Court of Appeal has for many years taken the view that BHS, Stores and Birchall was correctly decided, and applied not only to establishing the reason for dismissal, but also whether that decision was reasonable or unreasonable. Lord Wilson indicated, although the Supreme Court had not heard full argument on it, and he accepted as well that perhaps the BHS case took an extravagant view, his term, of the legislation, the effect of the decision was to require the tribunal to inquire whether the dismissal was within a range of reasonable responses, and Lord Wilson thought that was consistent with the obligation under Section 98(4) in asking whether the employer has acted fairly or unfairly. However, Baroness Hale, who, as you remember, is the President of the Supreme Court, said that this case might have presented an opportunity for the Supreme Court to consider whether or not the BHS case was correctly decided. She acknowledged there may be very good reasons why the Birchall test had not been challenged, and it had remained in place for nearly 40 years. However, she expressly said she was not going to give any view about whether or not the BHS test was correct, but only after having laid out her view that the BHS test did not, quote, fit well into the inquiry mandated by Section 98(4), unquote. So why am I going through this? Well, I think it's pretty clear that Baroness Hale, at least, is inviting another claimant on an unfair dismissal case to take an appeal to the Supreme Court on whether or not the BHS and Birchall case is correctly decided. Certainly, the BHS and Birchall test is long-standing, And I remember it was a newly decided case when I was at university studying employment law in my second year. And I remember learning the mantra for my second year exams, honestly believing on reasonable grounds after reasonable investigation, etc., etc. And I'm pretty sure there was a question on the BHS case in my second year exam papers. Anyway, I think if Baroness Hale has her way and this case is fully argued on appeal, it could be quite interesting to see whether the fact that the BHS case has been applied regularly for 40 years is sufficient to save it if there is a thorough examination by the Supreme Court of what the Employment Tribunal's obligations actually are when considering whether the dismissal was, altogether now, in accordance with equity and its substantive merits, unquote. So, that's the case of Riley and Sandwell Metropolitan Borough Council. And as I say, I strongly suspect we will be hearing of that case at some point in the future. And if there is any, I know I have the number of trade union reps listen to this podcast. If there's any trade union rep out there bold enough to have a go, you heard it here first. Anyway, those are the three cases for this podcast. Thank you very much indeed for listening to podcast 131. It's, as always, a pleasure doing them. Do keep an eye or an ear open for the Employment Lawyers Association podcast. I will put out a specific announcement when that's going up and how you get hold of it. But as I say, Judge Brian Doyle was an excellent guest, and it was a pleasure to have him on the ELA podcast. So until next time, 2 weeks off, stay safe, and as always, no employees were harmed in any way or mistreated in the making of this podcast. Thanks very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.